everyone. Today we are going to discuss the topic of the Government of India Act 1935 with special reference to provincial autonomy. And for this particular module, I am Dr. Sharmila Ghuge, who will be deliberating on this particular session. Objectives for this particular modules are to learn more about the phase prior to the enactment of Government of India Act 1935, to strengthen the knowledge pertaining to provincial autonomy and the constitutional framework of the said module. Well, we all are aware about the Government of India Act because that is the basic foundation of our Indian Constitution which we refer today. But in this particular module, we are going to talk about the basic introduction and the details of the Government of India Act with reference to the provincial autonomy. Well, the enactment of Government of India Act 1935 stands as a pivotal moment in India's constitutional history, profoundly shaping the nation's political framework. Instituted during the era of the British rule, the Act presented a comprehensive effort to reorganize the administration of British India. Its roots can be traced back to the Simon Commission established in 1927. Which recommended constitutional reforms in response to the escalating laws for self-governance. I am sure each one of us remembers the Simon Commission, and if I ask you all what comes to your mind, I am again sure you all will remember Simon Go Back on the placards. Yes, today we discuss the details with those references. A fundamental objective of the Government of India Act 1935 was to establish a federal structure and bestow increased autonomy upon the provinces. According to the official annals of the Indian Parliament, the Act aimed to establish a responsible government in India and provide for the setting up of a federation of India to deal with defence, external affairs and certain other matters. This marked a departure from the preceding Government of India Acts by incorporating provisions for provincial autonomy intending to empower the provinces with greater authority in managing their internal affairs. The autonomy of the provinces encompassed two essential aspects: the direct accountability of provincial governments to provincial legislatures and freedom from external control and interference across a diverse array of matters. Well, the Act had a wide-ranging scope covering diverse facets of governance and administration. According to the Encyclopedia Britannia, it outlined the establishment of All India Federation comprising provinces and princely states as units. Additionally, it aimed to navigate the intricate and multifaceted socio-political terrain of British India by distributing powers and responsibilities between the central government and the provinces. With this, let us proceed towards the historical perspective. Well, until the middle of World War I, spanning from 1914 to 1918, the British government did not recognize the urgency surrounding the constitutional trajectory of India. The imperative need to actively address the definite purpose of British rule in India became very apparent. On August 20th, 1917, Mr. Edwin Samuel Montagu, then Secretary State of India, delivered a momentous announcement in the Parliament outlining the objectives of His Majesty Government of India. He stated, "The policy of His Majesty's government, which is in complete accord with the Government of India, aims at increasing association of Indias in every branch of the administration and the gradual development of self-governing institutions, with a view to progressive realization of responsible government in India as an integral part of the British Empire." It was further emphasized that progression in this policy would occur through successive stages, with the British Parliament and the Government of India serving as the arbiters of the timing and extent of each advancement. This announcement univocably indicated that a responsible government in India integrated into the British Empire would align with the principles applied in the United Kingdom or the self-governing dominions. The British Constitution, evolving over centuries, has formed the foundation of responsible government across Commonwealth. Well, the idea was that there should be consistent interpretation of the same term when applied to different parts of the Commonwealth, avoiding disparate interpretations. This issue of distributing governmental powers between the provinces and the centre did not gain significant prominence until the determination of the federal nature of the central structure. The further entity to give considerable attention to this matter was the Joint Committee, a subcommittee on the provincial constitution and another federal structure formed during the initial session of the Round Table Conference. The terms of reference for the Joint Committee mandated classification of central and provincial subject as outlined in the first schedule of the devolution rules framed under the Act of 1909. Well, into exclusively central and exclusively provincial. The third category was subjects of interest to both the centre and the provinces to be the subject sent coordination. Well, the Joint Committee proposed the continuation of most of the existing central subjects. Overall, this committee recommended a new minor change that could be considered as extending the provincial sphere. Among the central subjects slated for total or partial federalization, the provincial government was granted power to exempt control of arms and ammunition from the requirements of Arms Act. Provincial accounts were entirely provincialized and development of industries to the extent not federalized was recommended for provincialization. Regarding central subjects with no proposed federalization, control of mineral development in contrast to the regulation of mines was recommended for provincialization. In the third category of provincial subjects subject to Indian legislation, criminal tribes, prisons, prisoners except state prisoners subject to central legislation were designated for provincialization. No other noteworthy changes were recommended. Nevertheless, this Joint Committee proposed slight modifications to the legislative control of the provinces by the centre by relaxing the regulations concerning the prior approval of the Governor General for the introduction of specific bills in the provincial legislature. The Committee on the Distribution of Legislative Powers was addressed this issue during the third session of the Round Table Conference. While acknowledging its inability to delve into specifics, the committee recommended the classification of subjects into three lists: exclusively central, exclusively provincial and, due to practical necessities, a concurrent list. The Governor General was to possess the authority to allocate any subject not explicitly mentioned in these lists. Thus, in conclusion, the imperative recognition of India's constitutional trajectory during First World War prompted significant announcement by Mr. Edwin Samuel Montagu in 1917, aligning India's responsible government with the principles of British Constitution. The subsequent attention to distributing governmental powers between provinces and the centre, notably the Joint Committee emphasized the classification of subjects and proposed minimal changes extending the provincial sphere. While modifications were recommended in the legislative control of provinces by the centre, the Distribution of Legislative Power Committee suggested three lists and granted the governor authority over unmentioned subjects. This intricate process marked a pivotal phase in India's constitutional journey, laying the groundwork for responsible and self-governance. Now, let us take a glance at the constitutional framework of the Act 1935. Well, under the 1935 Act, the provincial government's jurisdiction covers subjects legislated upon by the local legislature. This legislative and executive power of the provincial government as outlined in the Act are extensive, making distribution of powers between units and federation is evident. The Act of 1935 incorporates 3 legislative lists in its 7th schedule: federal, provincial and concurrent, and primarily based on white paper's classification accepted as satisfactory by the Joint Parliamentary Committee. While these 3 lists appear comprehensive, it was anticipated that unforeseen subjects might emerge not covered by the lists. In such cases, the Act empowered the Governor General at its discretion to assign residuary subjects to either the provinces or the federation's jurisdiction, including executive functions unless decided otherwise on a case-by-case basis. Crucially, these lists are an integral part of the Act of 1935, constituting a portion of the constitutional law. Consequently, no Indian authority has the capacity to modify the defined division of governmental spheres between the provinces and the federal centre established by the statute. With this, we proceed towards understanding the division of subjects. Well, the allocation of powers between the federation and the units is a notable aspect of the 1935 Act. Most subjects assigned to the federation pertain to the matters of extra provincial significance or are best administered by a central authority, while there might be a few exceptions such as salt, firearms, ecclesiastical affairs which could have been assigned to the provinces with some difficulty. The crucial federal subjects would likely have been challenging for the provinces to administer without jeopardizing India's overall interests. Consequently, it can be confidently stated that the scope of provincial authority has not been unduly restricted in any significant aspect. The division of powers appears to be primarily based on the principle that provinces should independently administer subjects of local nature, while authority over those extra provincial interests should rest with the federal government. However, what stands out in the distribution of powers according to the 1935 Act is the unique resolution of the question of residuary powers, making it an anomaly in the Federal Constitution of India. Unlike other federal constitutions enacted by the British Parliament, the disposal of residuary powers is distinct. In Canada, the centre holds the repository of residuary powers, possibly to counter-react the centrifugal forces. Conversely, in Australia, these powers are assigned to the units. Well, in India, it might have been conceivable to allocate residuary powers to the provinces rather than leaving them, as it currently is the case, to be determined individually by the Governor General as specific case arises. In the Indian context, where numerous of powers, especially emergency powers, have been granted by the federal government, the argument or strengthening centripetal forces have not been much merited. Well, a perpetual limitation on the legislative powers and autonomy of the provinces is imposed by the extensive authority granted to the federal legislature during a state of emergency that poses a threat to the security of India, which can be declared at the discretion of the Governor General. In such emergency situations, initially lasting for 6 months but extendable by Parliament, the federal legislature can enact laws on any subject in the provincial list with the prior approval of the Governor General. However, the laws passed by the federal legislature on provincial subjects during this period will cease to be effective 6 months after the state of emergency concludes. The autonomy of provincial legislatures becomes inconsensual during such emergency states. through a subsequent amendment in September 1939, this authority of the federal legislature along with other powers to enact laws for provinces has been expanded. Well, the list of federal subjects includes subject matters like implementation of treaties, industrial development, taxation on railway fares and freights, which could potentially be extended. Similar to constitutional interpretation, especially in the United States, to cover the regulation of affairs typically falling within the provincial sphere. However, the federal court will play a decisive role in such claims for power. In the United States, the Supreme Court has generally upheld the increasing assumptions of power by the federal government as legally valid. The stance of the Federal Court of India in jurisdictional disputes cannot be predicted, but so far there has been a tendency towards liberality in favor of the provinces. Let's take a glance at the provincial autonomy. In the case of Indian provinces, the concept of autonomy emerged primarily in the post-1919 period of that nation's constitutional history. The Government of India Act of 1935 established provincial autonomy, which was seen as a step forward in the introduction of responsible governance from local bodies to provincial government. However, this is only manifestation of the evolutionary course of the main currents of that movement. Well, as a connection between the centre and the provinces under the 1935 Act, provincial autonomy does not present an image of political entities completely independent within their domain, contrary to what one might generally envision of the federal constitutions or traditional federal philosophy. The Indian provinces' autonomy is limited by the inclusion of a generally reasonable list of subjects which they have jurisdiction or may have jurisdiction. The central Governor General having the final say over the allocation of reservable subjects. Additionally, the administration of provincial subject is further limited by the special safeguards that provided. In the case of India, the task of federalism was the balancing of unity and plurality, or the securing of equilibrium of the forces of plurality and unity. This was made more challenging by a unique combination of centripetal and centrifugist tendencies rooted in Indian and British culture. This resulted in the adaptation of the federal principle scheme with its special restrictions and responsible government in the Indian provinces, which still retained administrative units without cons and functions normally without federa. The Governor General's authority over specific areas of the Indian Constitution, which taken together is consistent with the country's development. A tendency towards a powerful central and a gradual increase in decentra, the provincial governments which a decisive supremacy. However, these restrictions are a necessary part of a system that denies sovereign power to any Indian authority and does not establish a fully responsible central government, because as long as sovereign power is exercised from outside of India and there are significant deviations from the principle of responsible government at the centre, complete autonomy and responsible governance for the provinces would be an untenable aberration, given that the Governor General's special responsibilities also extend horizontally to the provinces. Such limitations on provincial autonomy and responsible governance in the Constitution would have been simpler to eliminate, or if India had been granted dominion status as acknowledged by the Statutes of Westminster in the year 1931. Well, the extent to which the Governor General's special responsibilities require the withholding of citizenship from India's is a matter of debate and Indian culture. It is difficult to determine to what extent the existence of the safeguards contributed to the powers being threatened, but operations of the Constitution in the rally of 1937 to 1939 has demonstrated by the governor's use of his discretionary powers against ministerial advice only that safeguard against which the responsible government was threatened. Well, moving ahead, it is important to highlight that the impasses were not caused by constitutional issues, but rather by political motivations, as evidenced by the consistent approach taken by the governors and the political appointed ministers under strict control. If the unity had merely been a matter of constitutional practice, this observation should have been made later on regarding the Satyagraha campaign in various provinces. Overall, the 1937 to 1939 Constitution was implemented smoothly, a fact that has been attested by more than just Indians. This positively impacted not just the governors and the permanent official ability to adjust to changing circumstances, but also the capacity of the popular ministers. Further, constitutional advancement in India is warranted by the way the new constitution has operated in the provinces generally between the year 1937 and 39. Though there are some room for expansion of the provinces' authority within the Indian Federation, the primary need to preserve a sound balance between unity and plurality should not be overlooked. Ultimately, the advancement made entailed the assumption of full responsibility at the highest level of Indian government, with the result that the provinces grant a greater degree of autonomy and ensuring adjustment to the role and authority of the province chief would be entirely compatible. With this, we proceed towards the conclusion on this particular module. Well, the Government of India Act 1935 occupies a pivotal position in the annals of the India's constitutional history, epitomizing the intricate interplay between British colonial rule and India's fervent pursuit of self-governance. Enacted as a response to the recommendations of the Simon Commission, the Act embarked on a mission to reshape the governance structure of British India, assuring in a federal framework and bestowing augmented autonomy upon the provinces. Distinguished by its departure from preceding legislative frameworks, the Act placed a pronounced emphasis on the provincial autonomy. This revolutionary approach envisaged provincial governments as directly accountable to their respective legislature, liberating them from the external interference across a diverse spectrum of matters. The conception of an all India federation comprising both provinces and princely state sought to grapple with the intricate socio-political mosaic of British India by meticulously delineating powers between the central government and the provinces. The delineation of legislative powers between federal, provincial and concurrent lists provided a structured framework, yet the Act's unique provision entrusting residuary powers to the discretion of the Governor General imparted a distinctive characteristic to India's federal constitution. Despite the autonomy accorded to provinces, the Act incorporated safeguards and limitations, particularly evident during states of emergency, underscoring the delicate balance inherent in the federal design. Well, the notion of provincial autonomy germinating in the post-1919 era found culmination in the Government of India Act 1935. However, this autonomy was not unbridled. The Act imposed constraints including the discretionary powers vested in the Governor General and special safeguards in the administration of provincial subjects. The operational dynamics of the Act illuminated the inherent challenges of harmonizing centrifugal and centripetal forces with the Governor General retaining substantive powers. While the Act represented a momentous stride towards the realization of responsible self-government, its provisions fell short of providing absolute autonomy to provinces. The constitutional developments witnessed during 1937 to 1939 underscored the imperative for further progress in India's political landscape. The Government of India Act in 1935 has laid the foundational stone for the present day Constitution of India, paving way to be known as one of the best constitutions in the world. The Constitution has 315 articles incorporated from the Government of India Act 1935. The journey towards India's constitutional future pivots on the aspiration to achieve a more comprehensive measure of independence for provinces, all while meticulously upholding the judicious equilibrium between the central and the provincial powers at the national level. With this, we end this module over here. Thank you very much.